Mr. Hobby, you referenced in your argument why the highest level of scrutiny should not be applied. But what I'd like you to address is why the medium level of scrutiny should not be applied here. And that's the level of scrutiny that's been applied historically to gender over the last 3 or 4 decades of jurisprudence on this topic. Why shouldn't we be allowed, this court be allowed to apply the medium level of scrutiny?
Well, as is stated in Rebuttal Round, it's proven that the cases in which the dispute is between homosexual, like when the dispute pertains to homosexual marriage, that this is not a case of gender, because as is stated in Rebuttal Round, no one race is being, no one gender rather, is being placed above the other. Both genders are being held equally in that they may not marry each other, so therefore intermediate scrutiny should not apply because it's not a matter of gender.
And just quickly, so even if these laws don't classify on the basis of gender, why shouldn't we say that they reinforce gender stereotypes? That is, they reinforce the idea that men should marry women and that women should marry men. That's just a gender stereotype.
Well, although that is true, it's not really reinforcing any gender stereotype per se, considering the fact that this law is not preventing the union or the actual coming together of the two same genders. It's only preventing the title of marriage from being increased. So there's still other alternatives such as civil unions and a domestic partnership. It's just the title of marriage which keeps people from allowing this to happen.
Councilor Hobby, I'm interested to hear. Let's say that the court's not persuaded by your argument about this strict scrutiny analysis being used here to determine the constitutional question of the law. If we apply scrutiny, okay, let's say that we would apply it. Do you agree or disagree that we would have to say that this law is unconstitutional?
Well, I would disagree on the premise that scrutiny should be applied, but should be applied. One can consider the protection of the American population and the protection of our children a substantial government interest. And therefore, this policy can, in effect, be seen as merely terrible, considering that the only other way of preventing the decline of the American population would be to force people to have children. And this is, in essence, a narrowly chosen way to achieve this goal.
Well, let me tell you, under strict scrutiny, what bothers me is that when we used to talk about it being narrowly chosen, it should really be the only way to get the job done here. And why could the legislator, for example, come up with tax credits that they would provide to couples if they have children?
Because then, in that case, that would be seen as another form of discrimination by the government. And so, to prevent that from being another issue that will be placed before the court, we ask that this method be seen as another alternative.
Councilor to respond. My question is, the existence of DOMA notwithstanding, this couple was able to legally get married in Massachusetts, and then when they returned to D.C., they were able to legally live as a married couple, seemingly without any interference from the government. So my question is, what exactly was their injury? I mean, you're here asking us to rule that this law on its face discriminated against them and didn't allow them to get married, but they were married. So my trouble is, what exactly is the injury, and what exactly is the relief you think this court should be giving?
Well, first of all, although they were able to officially marry Massachusetts, when they moved back to Washington, D.C., they did not recognize that marriage. So in that state where they had their home and everything, they couldn't be recognized as a married couple. But I think the important thing is that marriage is one of those things that's of fundamental nature, and it has been an important part of our history for a very, very long time. And part of the reason that this case is in this court is because we all understand the importance of marriage, and certainly people of opposite sex also view this as an incredible opportunity. And there are many advantages that come with marriage. For example, in our case, when Amy is not even able to receive any of the benefits that because of Michelle's passing away. So, and those benefits include because they were married, and Social Security and other taxes, which would be better, and the home, that the Georgetown home that they had, would not even go to her because of this law. And so basically, in that relationship, there was one person who supported and one person who didn't. And because of this, there is a significant burden now on one person, and this burden would not have been if they were recognized as a married couple.
Counselor,
Marathon. I would like to ask the court why it is that the issue has been brought, that this issue has been brought before the court only after the death of Mrs. Amy Balik's life partner, and the issue of the estate has been brought up. Why wasn't this issue brought up when Amy was denied at first the ability to marry her spouse? Was it just this case is in effect motivated by the desire for the estate as opposed for the desire for the estate as opposed to the desire to actually marry her partner?
Counselor Ed, I'm not going to try your last You criticize the justifications for the law that are based on procreation and childbearing, saying that they're weak. But there's another justification for the law, which is just based on morality. Right? We have lots of laws in the United States that are just based on morality. A lot of them have to do with marriage and relationships. So we say, for example, it's immoral for people to engage in incest. It's immoral for people to engage in polygamy. And we don't allow that, right? So why isn't that a sufficient justification here?
First of all, dealing with other types of cases such as a polygamy, that's a very different case, and in that case, there's a very different way of how that kind of marriage affects women in that relationship, and that case should go to court on its own merits. Can you repeat the question?
Yeah, so I'm wondering why we can't ground this law, why a sufficient justification for this law isn't just based on morality. It has nothing to do with procreation or childbearing. We just do it wrong for people of the same sex to marry. Why isn't that sufficient to uphold?
First of all, I think this is...
Or we allow legislatures to judge this.
First of all, this is such a controversial issue, and people's morals are different. So there isn't one way that's morally was correct, because for a long time, people morally believed that segregation was appropriate. But when that case went into the Supreme Court judged objectively and not by tradition. And we should do the same thing here and judge by objective reasons and whether the government's interest is substantially related to its interest of trying to decrease birth rate and violence. And those interests are not at all substantially related.
Mr. Brody, I have a question on this one. Looking at trying to determine the appropriate level of scrutiny, one of the factors, of course, is how powerful a group is. And isn't sort of a history of this case an example of how a same-sex couple lacks power in society? Right. When you look at the history of this case, isn't it an example of how a same-sex couple lacks political power in society?
Not to a certain extent, but then when you look at it, when one scrutinizes the situation, one will find that the homosexual community is actually, like as I studied from my argument, that they are actually pretty highly organized, and that they actually have a certain degree of political power that wasn't actually wasn't afforded to people of other different groups, like different religious groups and different ethnic groups. And there are a lot of gay, homosexual rather, party members, a lot of homosexual politicians who reinforce the fact that there is actually a strength in the homosexual community in terms of politics.
One of the things that the plaintiff mentioned in the oral argument is that gays and lesbians, they have substantial political power. They have some gay TV shows which can influence decisions. But just because they have some political power, they have some TV shows, does not mean that they have as much political power as any other groups in this group. They still lack a lot of political power. They still lack a lot of representation.
So can I interrupt you and just squeeze the question in, Councilor Blasco? And you're saying that this is discriminatory, but if marriage has been between a man and a woman for centuries, and DOMA is simply stating a fact that currently exists and has existed for centuries, then how is it a discriminatory legislation if it simply is putting down on paper what existed historically? And if it's to change, why shouldn't that be the province of the legislature?
Well, first of all, as the Supreme Court said, we can't just rule cases because by tradition and how tradition defines the sort of classification. Because for a long time there were many things that were viewed traditionally morally correct, but then after years the court realized that these things are wrong, and when you view it as objectively and reasonably, that it doesn't satisfy those standards.
That's time.